As we move on here, there are different elements for a hostile work environment case, again, because the type of sexual harassment is a little bit different. Again, here we still have to be able to show discrimination based on a protected class. And again, this just goes back to our Title VII protected classes. Again, we know sexual harassment is included in that. Second element here is the plaintiff would have to be able to show that they're the subject of unwelcome advances. So basically, this just means that you are directly being harassed or addressed by the advances that are occurring in the workplace. So again, that could mean that you're sitting near someone who's constantly making comments or jokes about your appearance, and that's an unwelcome advance, not something that you are seeking or want to occur. So that's subject of unwelcome advances. The third element here is that the harassment itself has to actually affect some element of your employment. So and you can see here the element itself says a term, condition, or privilege of employment. Basically, you just have to show that this environment that's created from the sexual harassment is affecting your ability to do your job. So perhaps the employee that is harassing you on a daily basis is making it difficult for you to go to meetings because you don't want to be around this person, or it's a distraction to you when you're trying to make phone calls. Any of these things could be an argument for harassment affecting a term of employment. Here's another example case in our field. This is a specific hostile work environment case. So a lifeguard at a public beach brought a hostile work environment case against her supervisor and the city itself, which owned the beach. So the city had recently updated its sexual harassment policy, but it had not communicated it to lifeguards and supervisors. And in this particular case, which actually went all the way up to the Supreme Court, the city and the supervisor were both found liable because they had created the system to provide training, but they hadn't actually delivered it. So this gets into our next point here, which is that in a hostile work environment case, that concept of strict liability doesn't necessarily occur if the organization can show that they put in reasonable care, prevention, and action to keeping these sorts of things from happening. So if a K&R organization has sexual harassment training procedures that they have all their employees go through, if it's clear that they are trying to prevent these sorts of things from occurring, then they may not be strictly liable in a hostile work environment case. Again, that's a little bit different than the quid pro quo cases where they were regardless, right? Regardless of any actions they were taking in a quid pro quo case, that liability could go all the way up to the corporate entity. But in a hostile work environment case, because it's not deemed to be as severe, if the organization can show that they've taken some steps, some reasonable care to try to prevent this sort of environment, then that liability may not go up to them. So again, this goes back to the importance of having policies in place, making sure that you're properly training employees so that this sort of thing doesn't happen at your organization, making sure there's actual accountability for those that do participate in either hostile work environment, sexual harassment, or quid pro quo. Supervision is important, particularly if you're dealing with a lot of young employees who may be unexperienced in the workforce. And then ultimately, a lot of these issues surrounding sexual harassment can be prevented through having a workplace culture that simply doesn't accept this kind of behavior. And that kind of culture can be positive if it's done correctly. But if a culture exists where that sort of behavior is ignored or pushed under the rug, much like it was with the Dallas Mavericks, and then that can be really harmful to your organization. So there are things we can do as practitioners to try to eliminate or at least minimize risk for these sorts of claims. Okay, I'm going to pause right here and then come back to you with a very short lesson here on the Age Discrimination in Employment Act.